The birthdays are all over, the committee members. 2 birthdays anyway, down. And, Senator Norris and I are another year older and deeper in debt. I think that's the way the song goes.
Yeah. What do you get?
So we're Wednesday, April 24th, 2024. We're taking up H780 and act relating to judicial nominations and appointments. And we have Eric and Patrick to do a walkthrough of the bill. And I don't know if Tim Ash wants to, former senator and member of the committee and member of this committee and the nominating committee, may want to speak on it. So we can check with Tim at Vermont.gov if he wants to speak on it at our next meeting. So basically, Eric, this somewhat changes the judicial nominating process.
Yes, yep.
Modernizes it. So 2 members of this committee are currently on the judicial nominating board, and I was on the judicial nominating board at a time when actually Jeffrey Amistoy was appointed Chief Justice, but that goes back a ways. And Chief Justice Breiber was on the judicial nominating board with me.
Oh, is that right? I didn't realize that.
Yeah.
Yeah.
Just a Rutland attorney at the time.
Right.
So, anyhow, why don't you walk us through the bill?
Okay. Good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel to do a walkthrough of H780, which is an act relating to judicial nominations and appointments. As the chair was saying, this has to do with several different procedures related to the judicial nominating procedure. The first section deals with the Judicial Nominating Board. That's a constitutionally created entity. JNB is created in Section 32 of the Vermont Constitution. I'll just read that real quick because it's going to come up later as well. The provision in Section 32 says the governor, with the advice and consent of the Senate, shall fill a vacancy from a list of nominees presented by a judicial nominating body established by the General Assembly. So specifically provides for the creation of this judicial nominating body by the General Assembly. Interesting addition to that is a couple of sections later in Section 36, the Constitution expressly grants the General Assembly the authority to, quote, establish procedures for the implementation of that section. So the General Assembly specifically granted legislative authority to legislate in the Constitution about creating this judicial nominating body, and that's what the General Assembly has done. So you have the judicial nominating body boards, in statute, created with a variety of procedures related to how they conduct their business and who is on the board, on the body, and that is what's addressed in Section 1 of the bill. Right now, JNB has 3 members of the Senate, you're indicating Senator Sears, 3 members of the House, 2 members appointed by the governor, and 2 members elected by the Vermont Bar Association. So that's 11. See? Actually, it's 3 by the Vermont, I think it's 3. There might have been 1 short there. 3, and 2. I didn't want to short you guys, sorry. So 3 senators, 3 reps, 3 elected by the bar, and 2 appointed by the governor right now, 11 total. So the proposal that you see in Section 1 is to increase that membership by 1. So it wouldn't be 11, it would be 12. And who would the 12th member be? It's identified by name, specifically, not by position, I should say, not by name. On page 2, line 3, the Executive Director of Racial Equity or designee. So that would be the 12th member of the JNB. That's Section 1.
Why is that policy?
I think the in general policy, not necessarily through every particular piece of the bill, but a general policy that was motivating the bill was to try and expand the universe of candidates who would be heard by the board.
No, I guess I misphrased it. All the others are appointed by the committee from amongst, or the speaker or the governor or whatever.
Mm-hmm.
Why isn't the executive director, I don't have a particular problem with her appointing someone, but why is she automatically on or designate? Why isn't it the same as every other office holder. You know,
Yeah.
the three senators are appointed by the committee on
Right,
committees.
right.
I mean, if she wanted to name herself, or a member of the committee on committees wanted to name themselves, I'm sure they can. There's precedent for that, but I just, this is the only position that appoints itself or is designated. I don't mind her appointing somebody, and if she wanted to appoint herself, she could. But I'm a little concerned about that change of.
Yeah, it's an interesting point. I don't know that they talked about that particular issue, you know, so, I don't recall, it's possible, I don't recall.
Well, it's very
that coming up.
divergent from what we've normally done, and then the next year, somebody else will wanna.
Yeah, you certainly could
Maybe I'm
phrase
off
it,
base.
you could phrase it as a person appointed by the executive director of racial equity.
Yeah.
That's kind of what you're getting at, yeah. They'd be free to appoint themselves, as you say, if they chose to.
Senator Shane.
Thank you. I imagine you've gotten this question already, but 12 members, you have 6 people voting yes, 6 people voting no. How would a tie be broken?
Yeah, I think they reached the conclusion that ordinarily, that doesn't happen. That usually there's some majority one way or the other. And that they recognize that as a possibility, but that they were sort of weighing the frequency, would that how often that really happened with the policy they were seeking to advance by having that additional member, and they came down on the side of making it an even number, even acknowledging, as you say, that there's at least the potential that could result in a tie.
So I guess then there was a tie. Hypothetically, we would just figure it out. I mean, I don't know what. Or maybe that's a question for the chair.
Yeah.
Or.
I would think a tie would result in not sending someone up,
Yeah, I think
right?
maybe we need to be explicit.
Yeah. Yeah, I would agree.
Yeah, I feel like with something as important as a judgeship, if the committee can't come to some majority, then maybe it shouldn't go
As an
forward.
interesting sidelight, when I was on the judicial nominating board, there was heavy controversy about appointment for Chief Justice. And Governor Dean had made clear who he wanted. And the committee determined he was not qualified for that position. The committee, majority of the committee, maybe not all of us, I would think I was in the minority, didn't want the person that the committee chose. So it was a standoff between the governor and the judicial nominating board. It was an interesting, Bob probably remembers clearly. And I always thought of that as, you know, that proved to me the importance of that committee to not send a name to the governor that they didn't feel was qualified. And then Howard Dean, as he normally did, fell out of a tree, landed on his feet. The then Attorney General Jeffrey Amistoy was selected by all and did an admirable job. And he appointed a Republican as Chief Justice of the Supreme Court.
Dean did?
Dean did. Amistoy was a Republican Attorney General. Back when Republicans had moderates like Jeffords.
I don't remember if it was Governor Howard Dean or Governor Dean C. Davis he was talking about. He was governor.
Howard Dean. But anyway, that was a point of where there wasn't, and if there had been a tie, I think it should be explicit that tie does not get you there. Because it could have easily been. Members were very divided without divulging any of the information. Senator Norris.
Yeah, I was just, not that I have a problem with Director Davis or her appointee being on here. I just wonder why they stated the executive director of racial equity or designee, because I know, I guess I can understand the reason for it, but the positions are advertised, and just because we have certain members on the board doesn't mean everyone's going to apply for the position. I think it's going to enhance people applying for the position. If that's their goal, I mean, I don't have a problem with either one of them being there, but I do have concern with 12 members versus 11 or 13 too. I agree with that. Senator Sheen on that.
Yeah, I think, if we do make it clear that if there's a tie, the name doesn't go up. I mean, if there's that much disagreement
That takes
or
care of that.
divisiveness, but I just wanted to make sure there's a solution to that rather than if we encounter a tie and there's no language, we're just left there kind of saying, oh, we haven't had this before, now what?
Like a school vote, just revote it, right?
Just revote?
Just revote, it's a
Yeah.
school vote, just revote it.
Yeah.
So Eric, what was the reason for this particular position, the executive director of racial equity?
I think, as I said, they felt that would help expand the pool of applicants. I think that was their.
And what's the reason, how's that going to?
Later in the bill, there is excuse me,
Yeah, no, please do.
later in the bill, there is a piece that seems like it gets at that, where it says, this is page 6. The board shall consider the extent to which a candidate would contribute to a judicial branch that has diverse backgrounds and a broad range of lived experience. Seems like that's the purpose of the bill to a certain extent.
I think that's one of the major purposes, yeah.
Yeah, and everything is sort of pointed that way. How could you reasonably expect to broaden the judicial branch? And then are there things that we could do in the process to enable that?
And those questions come up quite often.
Yeah, I was gonna say, it does feel like we do talk about that, and this is with the note that, what we talk about is confidential in there, but it feels like this is something we generally discuss, when going over things. But I think, at least from my perspective, I think, having the executive director or their designee in there is less to, attract people, but more to have the perspective of that office on the board, providing input for the candidates that we get, if they are coming from different backgrounds or not, or, in my opinion, I think it's more so to have perspective from that office. That's how I see it.
This proposal is, and I don't know what else is in the bill, came from a report that the Office of Racial Equity did on, I think it was in 2021, looking at doing exactly what we asked them to do, which was looking at all of our branches of government and making proposals to create more diversity, and this was one of their proposals.
I do have a question, if we're going to jump around. This idea on page 7 of the governor can only request additional names once.
Yes, that's to address.
What is that?
That's to address kind of a situation you were alluding to, that there have been several occasions over the years where the governor has sent the list back to the Judicial Nominating Board. Judicial Nominating, and the standard that's used is well qualified now in statute. So anybody who the JNB determines is well qualified gets sent up to the governor. And the governor then picks from that list. Several times over the years, not with governors of different parties, so this is an issue of legal authority of the branches, not an issue about any particular political party, because this has happened with Democratic governors and with Republican governors, that they will decide that they want someone, or they don't want to choose someone from the list. So they'll send the list back to the Judicial Nominating Board and ask for another list. That has resulted in some tension between the branches, whether that's permitted under the Constitution, and there's arguments both ways on that. Remember, this is the language that I read earlier. My view is that the language that provides that the General Assembly can enact statutes to implement the purposes of the Judicial Nominating Board and other of those constitutional provisions, provides them with the GA to the authority, if you want to do it, to put something like this in law. So that's the idea. There's a compromise. So and in fact, interestingly, that language is related to, is very similar to there was a Senate bill that was introduced by then chair of the Judicial Nominating Board, Senator Flory, that did exactly that. I think it was 2018, 2017, something like that, to try to address the situation, because it's happened a number of times over the years. So originally, there was some thought upstairs about it being, you don't give them one more crack. You just say the governor has to pick from the list that gets sent. There was some pushback, as you might expect, from the governor's office on that, so this was the compromise they reached. That, all right, we'll allow one request for additional names, but only one.
So that's the major change here. There's also a section that allows somebody to use the military or some other thing as 3 years, and I'm not sure. I'm gonna,
That's just a tweak to existing statutes. So I'll tell you the difference on that. Let me back up to section 2 so that I don't lose sight of
okay,
anything.
walk through the bill in your own.
That would be nice.
We've been picking them apart.
So just real quick, section 2 has to do with, right now, when there's a vacancy, the Judicial Nominating Board sends out an email to all members of the bar and says, there's a vacancy in the judiciary. If you want, you can apply for it. Here's how you apply. There's an application on the judiciary website, et cetera. So in section 2, so it's basically a self-application process. You have to apply yourself. There's not a nomination procedure where someone else can nominate somebody. You self-nominate.
Unless we make this change.
Correct.
Yeah.
So what the proposal is in section 2 is you allow a procedure where somebody can nominate somebody else to be served on the board. I don't have to take it. They can decide not to apply, so they're not forced to apply just because somebody nominates you. But it sets up this procedure where the court administrator is going to put on their website a form that permits a person to nominate another person. And then if somebody uses that form and they nominate somebody else, then the court administrator provides the nominee with information about the application process, and they can decide whether to apply.
I'm just wondering what the impetus for that was, because it seems like, I don't know, it seems like if you're talking about being a Supreme Court justice, Superior Court judge, et cetera, you should be able to apply yourself. It just seems a little odd to have somebody say, I think you'd be great for this. I put in a nomination for you to be Chief Justice. I mean, or Superior Court judge. What was the energy behind adding other people making sort of?
I think trying to paraphrase, there was a feeling that some people who are qualified for various reasons don't think of themselves as qualified, and that they actually are qualified, but for other reasons wouldn't actually take the step of nominating themselves. So to allow someone else to nominate them would again expand the pool.
Do we want a Supreme Court justice who doesn't think they're qualified? I guess would be my, anyway, I think I understand the logic similar to, sometimes people will say of certain candidates for office that people don't think they can be a House rep or they can be a senator. And so they have to be encouraged to do that. Just, it seems like this will greatly expand the number of nominations you would have.
I agree.
And I don't know if it's fruitful to do that, but anyway.
Remember, they wouldn't necessarily, their application, they would still have to apply themselves. They can decide, well, thank you for nominating me, but I'm really not interested, and they decide not to apply.
Senator Bohowski may look at this differently than others, which she frequently does, so glad to hear from you.
Thank you. So first I want to just make sure this doesn't eliminate the ability for someone to nominate themselves. This adds the ability for someone else to nominate them. And
Correct.
Certainly, Senator Sears, you're not wrong. I do look at it a little bit differently. We have all kinds of research that shows women and people of color take 5 or 6 times being suggested to do something before they will do it, whereas that's not the case. And it sort of boils down, I think, to imposter syndrome in the societal context in which the global we, not we in this room, signal to certain groups of people that they are less qualified. And so I think this is a really important space to sort of expand who thinks of themselves as qualified. When we don't see ourselves represented in certain spaces, it's really difficult to see ourselves holding those spaces. So I do think that this is a really, actually, given that they still have to apply themselves, small way in which we could signal to groups of people that might not currently see themselves represented, that we would like to see them in those spaces.
I think another point to that is, I mean, some people don't necessarily catch every single email that comes in. If you might miss the announcement that there's a vacancy, and a lot of lawyers I know work long hours, beyond the 9 to 5, and I mean, I don't know, maybe it's a bit of a reach, but it's just one other thought. But the other question I had, Eric, and this might be a question for someone else, but the 10 years, is that consistent with what other states have for experience requirements?
I think it's a variety. I don't know off the top of my head.
Okay.
But I think it's a range.
Yeah.
So.
Okay. Thank you.
But thank you for the segue. If there's no other questions about the self-nomination or the having your name put in by somebody else, moving on to the next topic, that's over on page 4. Right now, the way the qualifications are set up for people who can even apply to be judges, there's some qualifications in the first place. And there's one that relates to legal experience. And the way it works now is you have to have been a lawyer in practicing law in Vermont for 10 years. And of that 10, the immediately preceding 5 have to been in Vermont, right? So you need to have 10 years total in Vermont and the 5 right before you submit your application. So you could have been practicing, say, in Vermont 10 years ago, go down to Boston for 10 years, come back, you still have to do that 5, you have to get 5 more right before you apply, before you would be qualified. Remember, that's the way it works currently. So the proposal, again, with this idea of trying to expand the pool a little bit, is to broaden that a little bit and to say, all right, well, the person does still have to be a Vermont resident, but they don't have to have practiced in Vermont for 10 years, they have to have practiced for 10 years, period. 10 years of practice, 3 immediately preceding have to be in Vermont, see? So it's a broader, hopefully, I think that's the intent, is to permit a broader range of people qualifying.
So if I'm reading it right, so we're going from minimum of 10 years in Vermont, current statute,
Correct?
to 3 in Vermont.
5 to 3, I think.
Well, no, it changes it to 3 immediately preceding.
That's right. That's right.
Yes, it's kind of wonky, the way you described how it currently is, that it's 10 total in Vermont, 5 currently in Vermont. And I appreciated the explanation you gave, that someone could have practiced in Vermont a decade ago for 5 years,
Right.
come back, and now has to do another 5 years in Vermont. So it's a little wonky currently.
But I mean, it's a sharp reduction in the number of years required to be in the state.
Yes, and I hate to contradict myself by now jumping forward to the next section. But as you were in King Center Group, that's connected to, over on page 6, that why they added an additional specific criteria for the board to consider line 11. Because you're right, that's a sharp reduction.
Is this for everybody or just the magistrate?
This is for the judges we're talking about first. There's a similar one for the magistrates.
Well, I'm looking at the one up above, it says the magistrate.
Above where?
It's up. On line 9, it says the candidate for magistrate
Right.
shall be a resident. So this is 2 just for magistrates or
Yes.
for everyone?
Yes, 2 is just for magistrates. They have a slightly different number set up, but yes, but they go by the same concept that we were just talking about for judges.
Yeah.
But yes, so number 1 applies to judges, you're right, Senator Sears, and number 2 applies to magistrates. Subdivision 2, I should say.
Senator.
Is there, I didn't see it, but one thing I'd like to explore a bit is the residency requirement in general. And what I mean by that is, a hypothetical scenario where somebody is living 10 minutes over the border in New Hampshire because we're in a housing crisis. They live in New Hampshire, they've been practicing in Vermont for 10 or 15 years, and they're well qualified, they meet all the other requirements. But because they had to buy their house right over the river or their apartment, they're disqualified and there's no room for discretion or making an exception. Is there any language in this bill that changes that or provides a little more discretion to the board?
They talked about that and decided not to go that route. And the reason they decided not to was they felt, I think it's Senator Bruce was just saying that they were already, by reducing the amount of Vermont experience that would be required, they were already taking a step in the direction of broadening the pool by expanding people who didn't practice in Vermont for their number of years that are required under current statute, and they did not also want to take this, they preferred to keep the Vermont residency requirement.
Senator Ashim and I are particularly sensitive to this, since many of the attorneys in our areas live out of state but practice in Vermont. And the key would be the practice in Vermont, not where they reside. And so we're penalized, for example, there's a public defender who could have served for 20 years, who may live in New York, has been practicing exclusively in Vermont, would be disqualified, but we're qualifying somebody who's practiced in New York, but happened to live in Vermont. And it seems kind of unfair.
Well, I hear you. I'm wondering, though, we are talking about a Chief Justice, and do you want a Chief Justice of the Vermont Supreme Court who lives out of state? I mean, it does seem unfair, but when you put it that way, it's.
Good point.
Yeah.
I think it's important to recognize that many people, for a variety of reasons, may live out of state and practice in Vermont.
I would want to add there, to this, if there were to be a change, that there'd be the obvious requirement that you move to Vermont if you make it through the process, not,
I can see that.
I would agree. I don't want a Supreme Court justice living in another state upon appointment, but, yeah. And, if we want to get into the weeds, we could also look at making different requirements, for a magistrate compared to a Supreme Court justice regarding residency and the years required in proceeding.
Actually, for me, of what we've gone through so far, the thing I have the most hard time with is moving to 3 years practice.
Yeah.
From 10 or more currently. That seems, and I understand that the intent is to broaden the pool.
Vermont law is different from other states that practice it.
I hear you, and I think, again, the way it's currently worded is so strange to me. Laws change frequently. Someone could have done their first 5 years 25 years ago, and is that still really relevant to law today? Or is the 5 years immediately prior really what's relevant?
Mm-hmm.
So I hear you, and I feel like, given that there's no limit on how much time can go between the first 5 and the second 5, it doesn't feel as sharp to me. It does feel like in many instances, it may really just be a reduction from 5 to 3.
Why don't we just complete the walkthrough? We're already 20 minutes behind. But we've thoroughly dissected the bill.
I lay the blame at Eric.
That's true. I was jumping all over the place.
Any witnesses may know, so
Mr. Chair.
you just try to briefly run us through the rest of the bill so I can get to the witnesses.
Yes, so I think we pretty much covered everything. One last thing, you kind of, alluded to this, Senator Sears, is that everything that we're just talking about in terms of, well, not everything, this immediately preceding requirement, you know what I mean? Under existing lots, the 5 years, but under the proposal here, it's 3. There's a certain amount of, prior to the application, there's a certain length of time for which the person had to have been practicing in Vermont. Under the proposal, it's 3 years. It preserves, the board has the ability to make exceptions for that. And that's in lines 5 to 7. And it doesn't really change it other than the number for the judges. It's just clarifying that the board can make exceptions, specifies the reasons, although it's not an exclusive list. It says that they can make exceptions to that requirement, that those 3 years have to be contiguous and immediately preceding, for reasons including family, military, academic, or medical leave. So, and that says including, so that's not an exclusive list. But just so you know that there is that option for the board, they could do the same thing with with magistrates. We sort of have already alluded to this, but the next section is adding, there's a long list of criteria that the board has to consider with applicants. That's existing law on page 5, integrity, legal knowledge, judicial temperament, impartiality, etc. And this adds 2 more to that list on page 6. The 2 that are added are the candidate's tie, this is subsection E, line 11, candidates' ties to the Vermont legal community and familiarity with the Vermont legal system. And that's connected to the issue of, well, since we're shortening the amount of time they have to have practiced in Vermont, add that criteria explicitly. And lastly, this one you referred to, Senator Bruce, already, is the extent to which a candidate would contribute to a judicial branch that has diverse backgrounds and a broad range of experience. And then, sorry.
Oh, I was just gonna say that one on lines 11 through 12 on page 6.
Yep.
That just seems a little weird to me. It's because it seems to me when you're talking about broadening and diversifying, you're trying to avoid the kind of in grouping that sometimes happens within a profession. And if you have to consider the candidate's ties to the Vermont legal community, what does that mean? Is it people come forward with affidavits in favor of you, or you belong to certain organizations, or it seems like it favors people who are in the know rather than people who might be trying to break in. And that seems to be somewhat in conflict with the next one, where you're looking to broaden. So, I don't know, 11 and 12.
I think, yeah, it's direction, but it's kind of, the board shall consider the extent to which a candidate would contribute to the judicial branch that has diverse backgrounds and a broad range of lived experience.
I think we already do that. To be quite honest.
Yeah. I agree.
I don't think it hurts to codify it if we're already doing it, just to really say that that is a value.
I think both of those are, so we'll hear the testimony, but I'm not sure if it doesn't confuse it further by putting in the statute.
Oh, one last question, Eric. On that last piece about the governor only getting one additional list.
Yep.
When the governor rejects the first list, asks for the second list,
Mm-hmm.
can the governor then go back to the first list under this?
Yes.
Okay.
Yes, exactly. It's,
So he really just gets an expanded list.
Okay.
In that case, it seems to me like if one was governor, you should just automatically reject the list and get double the names. You know what I mean?
I mean, if you really like someone on the list, why do that?
Well, it's one thing if you really have somebody that you're intent on. Otherwise, you can just get twice as many options.
I think when it comes to judges, it's not as big a consideration as when it comes to justice of the Supreme Court. That's the big appointment. I think that's when the governors get.
I think it'd be interesting, this did just arise, and it'd be interesting to see what our chair has to say about this particular thing once
She's up, Shirley,
when she comes on.
after Judge Zone. So I think we'll go to Judge Zone. Thank you.
good.
He's been patiently waiting for us somewhere.
New background.
Good morning.
It looks like he's got a log cabin
And this is actually real. It's not a fake background. So
no, it's real background.
it's
in
a real
Maine
background. I happen to be for a few hours today visiting with my dad before I head over to Philadelphia for a conference I'm attending. So for the record, So for the record, Tom Zone, Chief Superior Judge. Good morning. The bill is a policy bill, but I do have some comments I can add. The committee was questioning what happens if there's 12 members. On page 3, lines 3 through 5, it does say that in order to be sent up, there has to be a majority. And so I think that would address that. It would require it be 7 out of the 12, or the majority of those present to vote. So I think that is already addressed. Section 2 of the bill talks about the nomination process. And currently, if someone believes another individual might be well qualified to be a judge, they can pick up the phone, call them, send them an email, and say, hey, you should apply. There's an opening. This formalizes that process, and it may have the impact on someone who decides that, oh, wow, you think I'm qualified? Now, I certainly understand Senator Baruth's thoughts about someone's competence to do it. I also am aware that there are individuals who, as Senator Vyhovsky talks about, it's helpful to have them be told that, and someone might not know them personally well enough to feel comfortable calling. And so this is a policy decision, but if the legislature decides to implement this procedure, the court is able to put it together and make sure that it goes forward as intended. And so we certainly can do that. The provisions on page 4 that you were speaking about relating to the time, and this is a change. I would note initially that Senator Hashim talked about getting into the weeds and maybe looking at different criteria. Well, this does have different criteria for superior judges as opposed to magistrates, because the magistrates currently have to only have the 5 years, whereas a superior judge would have to have 10. And so this does change the magistrates. It goes from the 5 years for them. It then talks about the 3 in Vermont, where it had been 5. And as you've been discussing, it's 10 years practice in Vermont with that 5 immediately preceding currently for a superior judge. The change would allow, as Eric Fitzpatrick discussed, someone who may have practiced in a different state for 10 years, as long as they've been practicing in Vermont for 3 years, to be found to be well qualified and potentially appointed by the governor. This is a policy decision, but as I testified in the House, and I'll say it again, your ability to interact and be a part of the Vermont legal community as an attorney, I believe, is critical to the success as a judge that you will have. I don't think, for instance, that if I suddenly went to Maine and said I want to be a judge, and even if I practiced there for 2 or 3 years, I'm not sure that that necessarily would be enough, but it would be dependent on the individual. It would be dependent on how he or she is a member of the legal community. Do they immerse themselves in it? Are they active? Are they involved? What skills do they have? And so, as I view this provision, which is a policy provision, you go from a hard line saying this is what we absolutely require, 10 and then 5, to the, okay, it can be 10 out of state and 3. It goes from a hard line to that section that you were just discussing on page 6 about the candidates' ties, where the Judicial Nominating Board would essentially weigh out that factor and see, okay, does this particular individual have that connection that, again, I believe is critical to the Vermont legal community to be an effective judge and a successful judge. And then you also have the governor, who would be able to kind of vet that too. And so as I viewed it, it goes from that hard line to a soft line. And that's a policy decision. And having 2 members of the Judicial Nominating Board on this very committee, I think they have ideas, I'm sure. Do they think the hard line is necessary, or do they think that it can be managed as a soft line? That again, that's a policy decision. I will say that whether it's a hard line or a soft line, significant experience in the Vermont legal community, being a member of it, is critical to the success of anyone, I think, to be a judge in the state of Vermont.
Thank you.
And the final point I wanted to make was there's the request about the additional list that would go to the governor upon request. That's a policy decision. I think Eric gave a good hint about my view on that when he said that there's differing views, and he was talking about the Constitution. So I don't believe it would be appropriate for me to weigh in on that, because if there are differing views as to constitutional aspects of it, they would end up potentially in the courts, and I would not be in a position to offer any type of thoughts on that or advisory opinions as to how it would come out.
So one question for you, Judge. I'm curious about the 10 years, if you feel that's good where it is. Should it be more? Should it be less? Or, how is it, how does it compare to other states?
I don't know how it compares to a lot of states because many states have judicial elections, and I don't believe that's the type of requirement that would be there. I'm not familiar with other jurisdictions. I have no issue with 10 years for practice. It has seemed to provide us with what I think is a very talented bench in terms of a critical issue of experience.
Thank you.
Senator Brewer.
Judge Zone, I'm wondering, so my reading of page 4 at the top is that under the current system, you have a minimum of 10 years in Vermont practicing law. And we would go to a minimum, no matter what we did on how long you practice law, we would be going to a minimum of 3 years in Vermont. And I'm just wondering about how you feel. You called it going from a hard line to a soft line, but it's really a mathematical reduction of, a pretty dramatic amount. Are you comfortable with someone only having 3 years in Vermont?
I think that is certainly, when I say soft line, what I want are judges who have that ability to succeed and, again, have been involved in the Vermont bar, have been involved in the legal community. I do think 3 years is on the low side of where that could possibly be. 5 years is right now a number where it is basically at, given the fact that it has to be that 5 years immediately preceding. I think the 3 years is a low number, but are there people who potentially could meet the 3 years and still be immersed in the legal community and be effective and successful judges? I would think that there may be individuals, and that's where, when I say the soft line, that would be up to the Judicial Nominating Board to look at that individual and say, well, maybe a lot of people aren't after that 3 years. That might not be enough for everyone, but this one person, it might be. And so what you're doing is taking it and really trusting in the Judicial Nominating Board that it's going to critically analyze what I think is a very important aspect.
What I think, to follow up on that, Judge, for me, reading that, you also have an exemption to that timeline for military, family, academic, or medical leave. So it isn't really just a 3-year timeline. A person could be 6 months and have been in the military for 2 years and then taken family leave when they got out of the military and have been practicing 6 months. I think that's an extremely short amount of time. I'm not sure that the board would accept that, but it does give me concern when we lower the limit and we have those exemptions in there, which I'm fine with the exemptions, but when you lower that limit, you are really cutting most military service is what, 2 years usually?
I absolutely agree that if you have someone and it's 3 years and then there's exemptions made, it has the potential to put someone in a place where I would likely not find that they have the sufficient ties to the Vermont legal community. But again, that's why I refer to it as a soft line, because what you're really doing is shifting that decision over to the Judicial Nominating Board to decide.
Well, you've given us some food for thought. Are there any other, before you head to your conference?
Any more food?
Nothing further. Tomorrow I'll have a different background for you tomorrow. I believe.
Enjoy your time in Maine, and good to see you.
Good to see you. Have a great day, everyone. Thank you very much.
Thank you. Our next witness is Eleanor Schwartzwood, Chair of the Judicial Nominating Board, and I hope I got that right. Eleanor, welcome to Senate Judiciary. I think you already know 2 members of the committee. I'm Dick Sears from Bennington County.
I'm Phil Baruth, Senator from Chittenden Central District.
Senator Tanya Vyhovsky, Senator also from Chittenden Central District.
And you've met Senator Nora. They attend the meetings.
Good to see you, Alan.
How is their attendance? Could you give
So
us a
far, great.
report on their-
No complaints, and it's wonderful to see you both in your more natural habitat.
Yeah. Well, I understood that Senator Campion often misses the beginning of the meeting, so.
No comment on that. I appreciate all of my members' contributions, and they all do contribute, which is one of the wonderful things about serving on the board. We have many robust discussions in the course of our work, and it's really an honor to be able to work on this board. So thank you for having me today to talk about this bill. And I did miss the walkthrough, so I apologize if, just feel free to jump in and hurry me along or ask me questions as I go, because I'm not entirely sure what you've already discussed. I think I caught most of Judge Sone's testimony. So I am the current chair of the nominating board. I have been the chair for the last 5 years, and this will be my last year with the board. I'm about to term out. And just to set the stage for my testimony today, I'm here mainly to tell you about how the board operates and how this bill could affect our operations. I don't speak for the board as a whole. So like Judge Zone, I will try to leave the policy questions to you all, but I'm happy to answer questions within those parameters. So my plan today is just to sort of walk through section by section of the bill and let you know kind of how I see it affecting the board's operations. But again, if that's not helpful, if you have questions, please do interrupt me, because I am happy to be guided to whatever would be most helpful to you all. So diving in to section 1, my understanding is that this section of the bill would add a member, increasing our membership from 11 to 12. The new member would be appointed by the executive director of the Office of Racial Equity. This would affect us in a couple of ways, none of them, I think, too major. On the one hand, it would make, by adding a board member, it would add a little bit to the scheduling Jenga that we need to do every time we schedule a board meeting. We do struggle with scheduling 11 busy volunteers already, as our overlapping members can attest. On the other hand, it does not increase our quorum numbers. So in the sense of scheduling a meeting where we could reach quorum, which is 8, it would give us a little bit more of a cushion there. So operationally, I see that as kind of a wash. But more importantly, in terms of the racial equity lens, this is not a lens that is built into the board's current membership structure. I know that the board has gone through long periods of being quite racially homogenous. We have received some criticism about that in the past. And I know our membership right now is a little bit more diverse, but that really just depends on the folks that are currently responsible for appointing members. So the House, the Senate, the governor, and as I see it, adding a member appointed by the executive director of racial equity for the state would at least guarantee one member coming to the work with that lens. So that, whether that's a good idea is up to you, but that's the history as I see it from my time on the board. Any questions on that? Moving on to the nominations provision, which I see is the next section here. So section 2, the this adds a optional structure in which anyone can put forward a name and suggest that they might be a good judge. Currently, there is no structure for recruitment, and it kind of devolves to sort of everyone and no one is responsible for recruitment. We have at times struggled with low numbers of applicants for various positions. So, to the extent that this could help us with recruitment, that could certainly help with that problem. I am grateful that the Office of the Court Administrator seems willing to administer this because it does come with a bit of administration, it seems to me, and we appreciate all the assistance we can get there, given that we are a board of volunteers. So hearing no questions on that, I will move on to what you were just talking about with Judge Sone, which is the years of practice provision. And like Judge Sone, I see the years of practice, the reduction of years of practice in Vermont as in this section. What am I on here? Oh, this is still section 2, I guess. I see that reduction of years of experience as being very much tied to the next amendment, which is adding to the board's list of criteria the candidate's ties to the Vermont legal community. So I'm going to talk about those together. So on the one hand, you have a reduction, not in years of legal practice, but in years of legal practice, specifically in Vermont, from 10 to 3. And on the other hand, you have the board now being mandated to consider candidates' ties to the legal community in Vermont. And I see those as sort of working together. This is absolutely a policy decision. I agree with Judge Sone on that. I will say that in my experience as chair, one of the most common questions I have gotten and one of the most common reasons that people have asked whether they are eligible to apply and been told no has to do with the years of experience in practicing law in Vermont. So there have certainly been times when I've heard from folks who had, worked for 5, 10, 20 years out of state, moved into state, had maybe, 5, 7, 8 years of experience, sometimes 9.5 years of experience in the Vermont legal community, and wanted to apply to be a judge. And I had to tell them they were not qualified under the statute. So I do know that this could have a real impact on the number of people, the number of applicants that are able to apply. And what I will say about the corresponding addition of criteria for the board to consider the candidate's ties to the Vermont legal community, I think every board member will be able to attest that this section of criteria that's in the statute is the guiding light for everything that the board does when we're considering candidates. The board is very familiar with this set of criteria laid out in subpart D, 1 through 10. And I would see this addition of ties to the Vermont legal community and the other addition here, the extent to which a candidate would contribute to a judicial branch that has diverse backgrounds and a broad range of lived experience. I would say those would be added right into that discussion. And we spend a lot of time thinking about those criteria. We think about them when we think about how to structure our interviews, we talk about them when we consider how whether or not a candidate is well qualified. We always have a discussion at the end of the interviews that's really informed by these criteria. So in my experience, the board would take this addition very seriously. I don't know that there's much more I can say about that, other than that we turn back to the statute all the time. And we would do so here as well. Questions on that I can answer?
No, I think we're good.
Okay. Let's see. Moving on. Oh yes, so the final section has to do with the list. On my read, this amendment would allow the governor to request that the nominating board reopen the search and provide an additional list of persons who are well qualified, but that the governor could only do this once. My read on this is that in the past there has absolutely been tension between the board and the governor's office, and this is well predates my time. It predates Governor Scott's time. It's happened with governors from both parties, where for one reason or another, the governor is dissatisfied with the list, requests the board to send the governor more names, and there has been a real ambiguity in the law as to A, whether or not the governor has the authority to ask for more names, and B, whether or not the board must or could honor that additional request. So it's a policy decision what to do about that ambiguity, but I think it would, and speaking just as myself, it would certainly cut down on the time and energy spent on trying to resolve that ambiguity if the statute were a bit clearer about that. So I think that's what I can say on that front.
Having been through that process myself years ago,
Mm-hmm.
It seemed like Judge Zone, and I don't know if Eric has researched it or anybody has, is the constitutionality of this provision and whether or not it violates the Separation of Powers Act, or Separation of Powers, whatever. That's my main question. As a policy, I'm not really opposed to it. I think probably a positive policy, because having public engagement over a list that the Judicial Nominating Board is not allowed to talk about is very difficult. It's sort of like DCF trying to explain child abuse when they can't defend what their finding was because it's not public. And you are unable to explain, the press is asking you, and you're unable to say anything, basically, about any of the nomination process. The governor can say whatever he or she likes. So it's an unfair thing. So I don't mind this provision, but I do question if Eric is, anybody's researched the constitutionality of it. Judge Zone seemed to indicate it might be challenged.
I did research it. And I was comfortable with it.
Okay.
But I would also say that the governor's office has different perspectives.
I'm sure we did.
So we have different views.
Well, it would be helpful to quiz you further on your perspective, but I wonder if you have a perspective on this and the constitutionality of it.
I appreciate the question, and for my part, I appreciate the insight into the difficulties of what the board can and can't talk about. For my part, I am much happier to be the board than DCF in your hypothetical, personally. But the analogy is apt. And I didn't entirely hear what Eric said about the constitutionality. I personally don't see a problem with it. I don't know that it's necessarily my place to be here weighing in on the constitutionality of it. I am a lawyer, I am a constitutional lawyer, but that's not, I think, why I've been asked here today. But for what it's worth, if you need someone else to back up what I hope, or I assume Eric is also saying, I do not see an issue with his constitutionality.
Are there any other questions, comments? Thank you so much for joining us this morning. Very helpful.
Absolutely.
And your dog was impressive. You know,
Thank
stayed
you.
very calm during the entire process.
The pandemic was a great proving ground for her. I'm glad she behaved herself.
Thank you.
All right.
Our next witness is David Silver, or excuse me, Robert Paolini, and then David Silver. Are you okay, David, or do you have someplace you need to go?
Well, I would say age before beauty, but I think Bob's older than me. I'd like to get this done if I could, because I have.
Busy.
I appreciate it. And belated happy birthday to you, Dick.
Oh, thank you, David.
So I don't know, for those of you who don't know me, I'm a practicing attorney here in Bennington. I'm a partner at Bar Sternberg. Been a practicing lawyer in Vermont since 1990, and practicing lawyer since 1980. Well, 83 is when I started, but 84 is when I got admitted. So been doing this a while.
Just say, in Bennington anyway, even though you don't advertise, you're the guy to go to if you have some kind of a problem.
Well, thanks. Nice of you to say that. What I like to say is my greatest professional accomplishment is that I haven't died yet, and everybody else is retired. But no, I appreciate that, Dick. Yeah, I do a lot of criminal defense and trial work in the plaintiff's personal injury realm. I've also been on the judicial nominating board, and I served with Ella, who I think is wonderful, by the way. And I served with her, but I was on it for 6 years, even before she was on it. But I guess she was on it for the last 4 years, and then the first couple of years I was on it without her. And I've been on 3 federal judicial nominating commissions, the one replacing Judge Murtha, the one replacing Judge Sessions, and I was on the current one seeking to replace Judge Crawford. So I have a lot of experience with the nominating process that I bring to this. I'm going to say a few things. I'll just go through it. And I recognize that what I'm going to say is probably not, it's a little bit, it's controversial. Maybe we'll be fall on deaf ears. But first of all, just starting, I don't think anybody's really been talking about this. I think it's fine to increase it to 12 members, but I don't think it's a good idea to just have a simple majority vote. I'll tell you why. The term well qualified is very vague and it's very subjective. But I think we can all agree that what we want are the best judges possible. We want excellent judges. We want judges that we can look up to proudly. So in order to get that, I think it's incumbent upon us to make that the nominating process sort of focused on excellence, and what, in my experience, especially with the current governor, we have sent up people who were unanimously selected by the board, 10-0, 11-0, and we sent up people that were 6'5", and the governor didn't even interview some of the unanimous people, and he chose over and over again people that were 6'5" or 7'4". And I think that was unfortunate, and I think that some of the choices were unfortunate. And if someone is really qualified, they should be able to persuade more than the simple majority. And I think that's important. And it's not in this part of the bill it was in the original House. It didn't come to you, but that's my position on that. I agree that the racial equity appointee is a very good idea. You know, one of the problems, I mean, I know from speaking to Barbara Rachelson, who was I think one of the people that was the impetus for this bill, that part of the impetus was to create more diversity on the bench. Well, one of the reasons we don't have diversity on the bench is because we don't have a diverse state. You know, maybe you guys up in Burlington, you see a lot more diversity than we do down in the rest of the state. And in the bar, there's just not that much diversity. Wish there was more, but there isn't. So having someone on the board that has that viewpoint is really important. And I agree with what Ella said, and I think it's really an important lens, as I think one of the senators talked about. So I really support that. One of the things that I want to mention and no one's been talking about is this in section. Mine isn't paginated the same way yours, but it's the section A. It's the initial thing where it talks about the governor shall appoint 2 members who are not attorneys. Senate shall elect 3 members. Only 1 may be attorney, and the House shall elect 3 members. Only 1 may be attorney. I think that's a really big mistake to limit the amount of attorneys on the board. There should be more attorneys on the board and not less. And there should be more attorneys on the board for a couple of reasons. I mean,
Yeah. Is this current law?
Yes.
Okay.
Yeah, it's the current law, and it's not an amendment. And I want to put this in your head. I don't, like I said, I don't expect it to go anywhere, but I think it's really important for you guys to hear that, at least from my perspective, as someone who's practiced law for 40 years. You know, it's a specialized area of knowledge. It's a specialized culture, and very, very few people that aren't lawyers know what a judge does day in and day out, unless you're living it. It's kind of like if you were trying to pick a Spanish teacher and you said, you know, we don't want anybody on the selection committee that speaks Spanish. I mean, no, I'm not saying that there's not a good role for people that aren't lawyers. I think it definitely should be, but limiting it like that is a mistake. And it's a mistake not only because they won't have the same insight as to what a judge does and the impact of judges' decisions on everyday people every day, but also they won't be able to evaluate the legal writing and legal acumen of the judge the way a lawyer can. And they'll have to rely on the few lawyers on the panel who may have different opinions, who may have different abilities to evaluate it. And the third thing, which I think is most important, is that the more lawyers you have, the more information you have about what the candidate is really like from his peers, because each lawyer, it's not the biggest bar in the world. So each lawyer has a network of contacts, and they can find out, well, you know, what is this person really like from people that actually know him, and many of the lawyers on the panel may actually know the candidate also. You know, we get and I think anybody who's on the judicial board will agree with this. The references that we get from the candidates are the least valuable way of evaluating a candidate. You know, they're a self-selecting group, and almost uniformly, they're extremely positive and with superlatives. Of course, every once in a while, there's somebody who's so bad whose their references don't like them, but that's the exception and not the rule. The best information you get are from lawyers and people that aren't referrals. And the more lawyers you have on the board, the more you're going to get that information. That's my 2 cents on that thing. I think going to the section that you've all been talking about, the residency requirement and the minimum time. Is there a question, or sorry?
Yeah, I did just have a question around this section. that you were just talking about, and I wonder if you have a sense of how many attorneys would be enough attorneys, because in your previous sort of analogy of, would you want people who don't know Spanish to be selecting a Spanish teacher? I would say yes, because you can be an expert in something, but not very good at teaching it. And so you would still need a mix of people who are also experts in Spanish, as well as people who would be learning from the Spanish teacher. So I guess my question, because as I count, maybe I'm wrong, right now the board can be up to 5 attorneys. How many is enough attorneys?
Well, I mean, that's a great question, and I don't disagree with anything you said. I think there's a very important role for non-attorneys on the board. Don't get me wrong. I don't know. The last board that I was on had 3 attorneys.
Mhm.
2 government lawyers and me. The one before that had 3 attorneys. So and I don't know if there's that many attorneys that are in the legislature, frankly. But I think 5 attorneys would be good, right? And I don't have a strong number, but 5 or 6 would be fine. But 3, I don't think is enough, because
Well, under current law, it can be up to 5.
right, but it really isn't. I mean, I don't know. It seems to me that if the governor wants to pick an attorney, he should be able to pick an attorney. He can. Why should the governor not pick an attorney? If the legislature wants to pick more than one attorney, they should be allowed to. They could be the best people to be on the board. I just don't think it should be limited. I'm not saying you should mandate a certain number of attorneys, but I don't think it should be limited. Because in my view, having more attorneys is better than having fewer or less. Fewer, I think is the word. I
certainly hear you that there's a balance, but my concern with no limit is we could end up with a board that is all attorneys.
Well, I think the simplest one is on line 11 of page 1. Just put a period after the governor shall appoint 2 members. Leave it to the governor to appoint. If the governor wants to appoint 2 attorneys, he or she could.
I think I'd be okay with the governor appointing 1 attorney, not 2.
Or, well, but we can talk about it.
Okay.
I think you make a good point. I didn't really figure out all the ins and outs of it, which is like what you guys do. But I think as a policy decision, limiting it to, limiting the amount of attorneys to, 3 to 5, I don't think is a good idea. I will also
sometimes don't have attorneys
right.
who are willing to serve. So that means to limit that, we could not limit the number of attorneys in the House and Senate, but at the same time, I don't think you can require somebody to be an attorney from the House or Senate appointments, because we don't always have attorneys available. I mean, I think if I'm not mistaken, the only attorney in the Senate is Senator Hashim. And I don't know how many are in the House. I don't think it's a very large number.
I've got several, I think.
Yeah.
Well, but Martin Lalonde doesn't practice anymore.
Representative Andriano practices. Representative Andriano practices, but he's not coming back. Joe Andriano.
Representative Mahaly,
Oh, yeah.
Mark Mahaly, I think Ann Donahue is trained as well.
Yes. She is. There's a fair number of attorneys over there.
Okay, David, go ahead.
Just going forward, I understand you want to increase the pool of applicants. I am very strongly opposed to limiting the amount of time a person should be practicing law. I mean, right now you have 10 years, which I think is, the absolute minimum level of practice. I mean, it's hard to explain it, but it takes a long time to become an experienced attorney. Most lawyers, don't get into court for years. Most lawyers are not trial lawyers. There's a few of us, right? There's the prosecutors, the defense attorneys, and some civil litigators. But most attorneys are not having that much experience dealing with judges. 10 years is, maybe it's just because I'm so old, but 10 years seems like it goes by pretty quickly. And there's a very vast difference between different people, some people with 10 years of experience and other people with 10 years of experience. I get that the board will have discretion, and I'm not against the 10-year minimum, but a 3-year minimum as a soft, as the judge Zone was saying, that a 3-year minimum of practicing Vermont. And I can't give you statistics or data, but I think that is ridiculously low. I think you could have, it's so important to have, and what Ella was saying is how the two sections work together. The one that talks about, that the board should, one of the criteria is, I guess it's on 10F. No, I'm sorry, 10E, the board should consider candidates tied to the Vermont legal community and its familiarity with the legal system. Instead of working together, I see those two criteria as contradictory. I don't think you can have extensive ties to the legal community in 3 years. I think 5 years is a hard line. And if you want to make exceptions to it, the board could maybe that is not a bad idea. But I think the hard line should be at 5, not 3. And I agree with Judge Zone that, in my experience, having that I will tell you something, almost every time we get someone with just 10 years of experience, most of the people in the Judicial Nominating Board say, gee, this person might be a good judge in a few years. That's the general feeling of, so, limiting their experience in Vermont. And Vermont is I think Vermont is unique in many ways in terms of the civility and that people deal with each other, the values that they deal with each other, as opposed to litigating in New York, which I do sometimes. I haven't litigated in other states other than New York and Vermont, but I can tell you there's a vast difference in the legal culture between the two states. So I think it's important. It's also important to have that person make connections and have a reputation from which we can judge the person. 3 years isn't very long for people to really understand, well, what kind of judge would this guy be? Or this, when I say guy, I mean this person, man or woman. So that to me is my position. It should be at 5 years. And I would like to talk just very briefly about the governors must pick from a list. I've been involved in controversies there where we sent the judges up list, we sent the governor a list of what we all thought were very qualified people. And he said, I want you to send me another list. If the governor can do that, then he basically takes away the limitation on his discretion that this statute is designed to provide. The statute is designed to give the legislature the right to limit the governor's discretion to pick anybody he wants or she wants. If the governor can reject every list until he gets something that he wants, then he is taking the discretion away from the legislature. And I think that is a violation of the separation of powers. I have no problem with saying that. But on the other hand, if the board can limit the list to like one person or two person, then we're taking away the governor's discretion. So, theoretically under the statute, you could send up one person. And if you send up one person, then you are really telling the governor, you got to pick this person. And if the governor doesn't like this under this statute, you send up another one person, and I think that would be wrong too. So I think you need to balance the two, the rights of each of these sections of government to exercise their discretion. And my suggestion would be that the amendment be changed to include a provision that if the board sends up the governor a list of 3 or less candidates, the governor could request another list. And the list should have at least 3 more candidates. Because that way, and the reason I say 3 is a practical reason, because when you have what we saw on the Judicial Nominating Board is that when you are advertising for a position in the southern part of the state, Bennington or Brattleboro, or even Rutland, you get much fewer candidates than if you have one for the northern part of the state. And we had times, several times, where we were berated by the governor for not giving them more than 6 people when we had like 9 applicants, and we picked 6 of them to send up to him. Or sometimes we had 6 applicants and we picked, 4 of them. I can't remember the exact numbers, but it's not the board's fault when you don't get this many applicants. And what are you supposed to do about that? So that's my position on that.
I think it's a point well taken. I think that it describes my experience when the board only sent one name to the governor and chief justice.
So I guess that's all I've got, people.
Senator Norris.
Yes, thank you. I may have missed it when you were discussing the 10 years with 5 years, the last 5 years being in Vermont. Did you comment at all on the magistrates' positions and their qualifications? I might have missed that.
No, I did not. I mean, I didn't even look at that, frankly. I know, is there a difference?
Oh, yeah.
Magistrate be a resident who has practiced law for at least 5 years and at least 3 years in Vermont. Yeah, I agree. I don't think it should be, I don't think that it should be anything less than what a Superior Court judge is. And I'll tell you something about, and this is a topic for another day, but I think it applies somewhat to this. One of the problems that a lot of us who practice in different courts find is that you got a judge who's got a lot of great background in family law. You put that judge in criminal court, and sometimes they never really get it. Then they're great in family court. And you put some judge who's really great in civil court, and then you put them in family court, and they don't, and that's not necessarily the rule, but it happens a lot. And I believe ultimately that there should be specialization of judges. And really, as a practical matter, I think that's what the judges, the chief judges tend to do. They tend to try to keep the judges who are good in certain areas in those areas. They try to do that informally. The magistrate's going to be in family court, and family court, you need a lot of experience. And I think I don't have a problem with, I think they should have, I think 5 years is low, frankly.
Should it be in Vermont?
Yes, I think it needs to be in Vermont. Vermont has its own practices and traditions and rules in family court, as opposed to, family court is a really state specific type of and I mean, there are policies that are generally accepted in all the states, but the rules are different in every state. And I don't think you guys you were talking a little bit about residency requirement, and I don't know if there's any, you were talking about like living in having an exception if you're living across the river or in New York. We live right, I'm in the southwest corner, we're close to Massachusetts and we're close to New York. I am a strong believer that the judge should be a resident of Vermont. And it's really for a couple of reasons. One is that, the impact of the judge's decisions, a lot of judge's decisions, is in the community, and they should be living in that community. And they should know the standards and the values of that community. And one way you do that is by living in it. You send your kids to school, you're involved in community activities, and you meet people, and you're part of the community, and you understand the ethos, and you understand the sensibilities of your community. And I think that's really important for a judge. Go ahead, sorry.
Yeah, just one caveat to that. If, so for the hypothetical, if somebody is, practicing in Vermont for 15 years or 10 years, whatever it may be, and, they're, like you said, living right over the border, do you think that having a carve out where it states that if you're appointed, then you have to become a resident? If previously they, the 10 or 15 years were spent practicing in Vermont?
No, I don't support that. I mean, I understand how it's sort of on its face, it seems reasonable, but the point that I was making is, where you send your kids to school, where you do your grocery shopping, where you you meet people at the community markets and the farmers markets and the people that and the politicians that you deal with and getting involved in the schools and local organizations. I think that's what informs a lot of your decisions as a judge, and you don't get that just by moving there after you become a judge.
I don't necessarily disagree, but the experience following the retirement of David Howard was Bennington County didn't have a resident judge for I don't know how many years until the recent appointments. So we had no one anyway from the community.
Well, but I'm talking about the Vermont community.
Okay.
I mean, Bennington actually, it's not well known, Dick, but Bennington is actually part of Vermont. And
I'm not sure. Sometimes we get treated as we're not.
I mean, because we've had judges from Rutland come here, like Judge Corsons, who I think is one of the best judges I've ever been in front of. And I don't see that the sensibilities and community standards of Rutland or Brattleboro or
I don't know if I'd include Brattleboro.
Fair enough.
I don't think they're so different.
Well, they're kind of on the eastern side, and after the interstate was built, they became hippie town.
Ooh, it was all the interstate.
The interstate.
I thought you would like them. There's a lot of Red Sox fans there. More.
Yes, there are more, and that's important, David. The more Red Sox fans we have, the better off we all are, as you know.
I'm surprised you don't put that as a requirement to be a judge.
Well, we didn't want to eliminate you completely. Our alleged counsel happens to be a Yankee fan too. Mr. Fitzpatrick even has a Yankee tie.
Sure, I got my Yankee tie.
I knew I liked him for a reason.
He has his Yankee tie on today.
All right.
We allow that here as long as I can wear my Red Sox hat.
I can't take off my Red Sox tattoo.
No, Senator Wahowski has a Red Sox tattoo, so we're a divided community.
You can get that removed.
Why would I want to?
Well, okay, you obviously haven't been paying attention the last couple seasons.
I love my team even when they're terrible. That's true fandom.
Well, I have the same problem. Okay. Well, thank you. If that's all, I'll sign off.
Enjoy, David. Thank you.
Thank
for
you.
being
Thank
with
you,
us.
guys.
Our next witness is Bob Paley,
Thank you.
representative of, he is the Vermont Bar Association.
Good morning. Bob Paley from the Vermont Bar Association. Thank you for having me. I feel at a disadvantage being behind following David Silva. Always difficult.
To say that David Silva is opinionated.
Yeah, some people say that. I have a lot of respect for David, and I've worked with him.
I do too.
On many projects over the years. A lot of what I want to say, and I won't take a whole lot of your time, you've already heard. But let me start with David's comments about the makeup of the JND under current law. Current law, there's a maximum of 5 attorneys that can be on that board. It's always been a little bit of a sore point for me and for members of my board, knowing that we're sort of always outnumbered. And then there are times when the Senate doesn't have a practicing lawyer, the House may not have lawyers. And David spoke about a couple of terms that he served where it was only 3 lawyers elected by the bar. A way to maybe solve that problem and maybe bump the board up to 13 if the present bill passes is for the Bar Association to elect 4 and not 3. It's doable. It maybe balances things a little bit. It's an option instead of taking away the power of the governor or requiring the House or Senate to do something. It's just the bar could add another number. to that list. Just a thought, but to follow up on what David said, going through the bill just sort of in order, on page 2, the addition of the executive director of racial equity, which is a gubernatorial appointee. That person is appointed by the governor. So in fact, the governor gets 3 appointments to the JNB, as opposed to just the normal 2 that are in current law. And I think that person, who we all know is a great candidate to be on this board because of her expertise. What confuses me a little bit, and I've really never thought about this in other statutory language, but the language that says "or designee" is sort of open-ended. It doesn't say designee with the background in racial equity. It's not Ms. Davis, who we know, but is it anybody? Well, I don't know how that's interpreted. So I think the addition of the director of racial equity is a good addition, but I'm concerned about the open-endedness of the word designee, if I'm reading it that way correctly.
Would it help to clarify if we say a designee from the Office of Racial Equity?
It may, but that was something, as I said, that's never hit me, it never occurred to me before. But having read this in the last couple of months, what does that really mean? I don't know, I just raised that for you, and for Eric to speak to you about.
I mean, I want to believe that the executive director of racial equity's lens would be to designate someone with an eye for racial equity. I hesitate to specify from that office, just recognizing how small that office is.
I understood,
Yeah.
totally understood, just something I needed to point out. I think David Silver alluded to this. There was discussion in the House committee about the finding of someone to be well qualified. I supported, I think it was in the original draft language, that the vote be by 75% majority, not just a majority vote, but 75%. Right now, I think you've heard that there's been some history of sending names that were found to be well qualified on a 6-5 vote. So if the board goes to 12 or maybe 13, there was a proposal that I supported, I think he did, that the vote be 75%. You're talking well qualified. For those of you, probably some of you know this, but maybe not everybody, but before the legislature increased the standard, raised the standard to well qualified, there were 2 choices. The JNB could find somebody not qualified or qualified. And that was it. That led to some people being found qualified. Their name went up to a governor who didn't appoint them. Then 2 or 4 years later, with a different makeup of the nominating board, that same person came back in, applied, was found not qualified. It was very confusing and very disheartening to a lot of people who found themselves in that situation. The standard was raised to well qualified. It's a pretty high burden. I agree with David. That's a pretty high burden. So I think requiring like a 3/4 majority is better than just selecting by majority vote. My third point is a person nominating another person. In the House committee, one of the witnesses who testified referred to the bar as chatty. The bar was chatty, meaning that we all talk to one another. And it's true, we do. Recently an announcement came out about an opening in the environmental division. As soon as I saw that, I thought, wow, I wish so-and-so would apply. I bet so-and-so would be a great environmental judge. That's how things work in this bar. We talk to each other. We make suggestions to each other. We call each other and say, there's an opening. It's in the Southern District. You practice down there, you should apply. You'd be a great judge. It happens all the time. I know judges call lawyers, say, you'd be a great judge, you should apply. This section about allowing a person to nominate another just confuses and bothers me because it's a little bit intrusive. It's like, you know, if you think that I'm a good candidate, call me and tell me that. Don't go sending my name to the court administrator and then me getting the packet in the mail saying, fill this out. No, you know, I'm just offended. I'm just annoyed by it. That's it. Just, I don't want to say much more about it than that. I just thought I should tell you.
This is part of your conversation, but I certainly fully understand.
I made a suggestion, Senator, I'm not sure if you were in the room. I think you probably were, but I said that the Bar Association could elect 4 members.
Right.
Instead of 3. Yes. Okay. In terms of the timing, I'm going to agree with the judge and with David. And speaking from my board, I think it was unanimous that, yes, the candidate should be a Vermont resident. And if we're going to reduce the time from 10 years practicing in Vermont, it shouldn't be any less than 5. I mean, going from 10 to 3, that's a bit much, and I would agree with everything that's been testified to earlier this morning. I think 5 is a good compromise. It's somewhere in the middle, and I think it works. I'm also afraid that if it stays at 3 years, then you go back, you look ahead to the new categories that were added to what the board should consider about ties to the community and familiarity with the legal system. You may be opening the door to more people to apply because it's only 3 years, but then you shut the door at the end when the board says, well, you don't really have enough connection to this system, you really haven't practiced here long enough. So I'm not sure that it accomplishes much. And I think David was correct that we're not a very diverse bar. It's going to take a while before we are. I think the intent of the bill is great to encourage diversity in the applications and in the eventual makeup of the judiciary. These kinds of tweaks are not going to do it. And I don't think it's going to increase the number of applicants. I think David was correct about talking about the regional differences, plus the fact that the life of the judge is very difficult. It's very different than what lawyers do in their law firms, especially the larger law firms. You all know that you've interviewed candidates for a confirmation. You know how isolating the job is. You know how lawyers who may have been in law firms with lots of support people, with paralegals, with administrative assistants, with secretaries, all of a sudden they're out there on their own. You don't have any of that. People think twice before filling out that application to be a judge. So I think that's the difference, is that the life of a judge is difficult, and that's what limits applications. Finally, in terms of the governor's request for an additional list or 2 lists, what happens now is what this statute is amended to say, that the governor can ask for another list. David floated that idea in House Judiciary, that if the list contains less than 2 names, I think he maybe said 3 today, or whatever it was, that the governor could ask for another list. And, you know, that's a compromise too, that I think could work.
I think, given my experience for the Judicial Nominating Board, I believe set one name on a Chief Justice and let the governor that kind of adversity, and then nobody can talk about it.
Yeah, and then that makes the legislature the executive as
Yeah.
opposed to, yeah, either way, there's a conflict.
There's a dynamic there, so I do think that I would be more supportive of an amendment that required, and if they sent more than 3 or more names, then the governor gets one shot. If they send less than 3 or 2.
So most of our other statutes regarding gubernatorial appointments kind of do it. I mean, they don't necessarily, no, they do. Like, I think about like the Secretary of Education, it says the state board shall supply 3 names and the governor shall pick from those 3. So it seems to me that we have precedent for other gubernatorial appointments to do exactly what you're saying.
Yeah. But you understand the dynamic when the majority at the time of the Judicial Nominating Board, I was not a part of that majority, by the way, wanted to just send one name.
Yeah, no, I'm appreciative of your sort of compromise point of saying, like, you need to give the governor people to pick from.
Right.
But he does actually have to pick from that list.
Right.
I'm agreeing with you.
Okay.
I know you that's not always the case, but.
No, nice. Anything else for Bob? Bob, thank you very much. Our final witness this morning is Jay Green from the Division of Racial. We all know the division.
Good morning, everyone. Thank you very much for allowing me to testify. For the record, my name is Jay Green. I use they, them pronouns, and I'm the Policy and Research Analyst for the Office of Racial Equity. I sent 2 pieces of information to the committee for review. I apologize that I only sent the Racial Equity Task Force report this morning, but I did send the language of H401 as introduced yesterday evening to Committee Assistant Donsbach. So basically, H401 and the recommendations for updating the Judicial Nominating Board from H401, which is colloquially referred to in our office as sort of the equity package, were designed to implement the recommendations of the Racial Equity Task Force, which was a 12-member working group that was created after Executive Director Davis was hired in order to make recommendations on how the state of Vermont can reduce systemic racism in state government. And one of the series of recommendations they made in the second Racial Equity Task Force report in 2021 was about this subject of updating the Judicial Nominating Board composition. So I've provided to the committee for your future reference a link to the second Racial Equity Task Force report, where they discuss the reasoning why it is important for our Judicial Nominating Board procedures to be updated to better incorporate a racial equity lens, and some research backing up the reasoning why certain recommendations were made. And then H401 contained the office's preferred language for how the Judicial Nominating Board could be updated. On the topic of appointing the executive director or a designee, it's challenging because Executive Director Davis is on leave right now, so I can't get her official position on behalf of the office, but I believe we have discussed that appointing the executive director or a designee would be our preferred language, simply because the executive director sits on a huge number of different committees and commissions and boards and such, and it would be beneficial to have the option to appoint a designee who could take on some of that additional work just due to the workload on the executive director's position. I disagree that the executive director of racial equity is another gubernatorial appointee in practice. Obviously the executive director of racial equity is hired and approved by the governor, but our office is not shy about speaking consistently from a lens of racial equity and justice. And even in cases where that runs in contradiction to something that the governor's office is proposing. I think we've seen that very clearly this legislative session with our office providing testimony on a number of bills that the governor's office has designated as policy priorities for them that our office has objected to on the grounds of racial equity concerns. So I feel pretty confident in saying that the executive director of racial equity needs to function from a lens of operating from a set of vision and values for racial equity and justice rather than the political priorities of whoever is in the governor's office. So yeah, we always try to bring those values to our work rather than relying on sort of the political pressures of elected officials. I think that if I had to guess, I would say that it would be fine to add some language to the effect of a designee with experience in racial equity work or a designee, with experience, relevant experience related to diversity, equity, inclusion, and justice, something to that effect if you wanted to specify exactly who the designee should be or what they should be focused on. But I will point out that the language from H401 actually recommended decreasing the size of the board from 11 to 9, from 11 to 8, and then adding the executive director for a total of 9 members, which would help with some of the operational. I really liked Chair Spotswood's comment about it being a scheduling Jenga. I can't imagine trying to coordinate 12 different people to get together for an all-day meeting. So that could be beneficial from a logistical standpoint, but again, I don't think that our office would object to merely adding the executive director or a designee as the 12th member. I can't personally speak to, so I'll just speak to what is discussed in the Racial Equity Task Force report with regards to the importance of including certain provisions. The H401 and the Racial Equity Task Force report both focused on the importance of expanding the pool of candidates by reducing the number of years that the person is required to practice specifically in Vermont. The point there, and I think that it's reflected in the language of H780, is not to force the judicial nominating board to accept a candidate who has been practicing in Vermont for 3 years or more, but to allow more people to apply, even if they have only been practicing in Vermont for 3 years. And again, this is, Executive Director Davis frequently talks about the problem of consistently pattern matching, because when we are always matching up future judges to the composition of our existing judicial panel or judicial population, then we're going to consistently be nominating more folks who match the current lack of diversity on the judicial board. So, changing those years of practice requirements is designed to give the judicial nominating board more leeway to consider candidates who might be deeply embedded in the Vermont legal community, well qualified, and have maybe only practiced in Vermont for 4 years or 5 years instead of 10 years, but maybe they've practiced in other states for 20 years. So they do have a very clear, long legal career to draw from. So
we try to finish up here.
So, while I appreciate Mr. Paolini and Mr. Silver, I apologize. Is it Attorney Paolini? Should I be saying Attorney Paolini instead of Mr.? I'm not good at titles. I apologize.
Well,
Attorney Paolini and Attorney Silver's input about the importance of judicial experience, of legal experience specifically in Vermont. The focus of our office and the focus of the Racial Equity Task Force report is that expansion of the pool of applicants and ensuring that people are at least given the chance to apply, even if they don't exactly match the existing patterns of who is a member of the Bar Association, et cetera. So Yeah, and along those lines, we strongly support the inclusion of making sure that the Judicial Nominating Board shall consider the extent to which a candidate would contribute to a judicial branch that has diverse backgrounds and a broad range of lived experience. I believe that's drawn directly from H401 of 2021. That is important not only because, maybe that is the current practice of the Judicial Nominating Board under Chair Spotswood, but we need to always keep in mind that we need to institutionalize the values of racial equity to combat the systemic racism that's already built into the system. So if Chair Spotswood was to, she's already going to leave her position as chair soon because of the term limit. And we would want to ensure that future judicial nominating boards, no matter who the chair is, no matter their composition, always know that it is a value of the state of Vermont that they need to consider the diversity of lived experience of their candidates. So from our office's position, it's very important that guidance be maintained under statute so that we have institutional continuity of considering the diversity of lived experience, regardless of who is on the board or who is the chair of the board. Regarding the process of submitting names for nomination, I think that Senator Vyhovsky said it very well earlier today that there's significant evidence that things like imposter syndrome, where someone believes they're not competent despite all evidence to the contrary, do affect people of color and women more frequently than they do people who fit into that pattern matching of like, you already look like and have a similar background or experience to the judges that are already judges here in Vermont. So why would you be less confident that you couldn't fit in with them? So I think it's very important that we, open the door for alternatives where people can get that boost of confidence from having another person nominate them. And I think formalizing the process is not necessarily a bad thing. I appreciate that it might be more congenial or polite or more supportive if you called someone directly and told them to apply, but that call doesn't appear in any kind of records. So, the Judicial Nominating Board won't see like, oh, so-and-so called me and recommended me, unless you list them as a reference, I suppose. But, I think that having on the record that someone else considers you to be a valuable candidate for this role could be a real confidence booster for people who otherwise don't match the patterns of who we see in our existing judicial population. So I personally, and from the office's behalf, support the idea of creating a nomination process. And again, this just because someone is nominated doesn't mean that they will choose to apply. A nomination through this process that's contemplated in H780 is not an application on behalf of someone else. It's a recommendation that they apply. So consider, and I've written down in my notes here that we shouldn't equate confidence with competence, because I'm sure that we all know someone who is extremely confident in their abilities, but is maybe not as competent in their abilities as they should be. So just because someone is extremely competent doesn't mean that they have the confidence to apply, and just because someone is extremely confident in their application doesn't necessarily mean they have the competence to serve as a judge. So I know that we're short on time here. Is there anything that I haven't addressed that I just wanted to say one more thing before I ask questions from the committee, which was that earlier in testimony today, Senator Baruth pointed out that the connections to Vermont's legal community tends to exclude people who are trying to break into Vermont's legal community. And I wholeheartedly agree that is one of the problems that the Racial Equity Task Force and that the recommendations from H401 were trying to combat by relying less on connections to Vermont's legal community, because I have heard so many stories and discussions from my colleagues of color about the sometimes racist macroaggression, like sometimes it's just straight up racially biased treatment that they've received, or sometimes it's in the form of microaggressions, which are, I know some people dismiss, but having been subject to microaggressions, they are not as micro as they sound. Things like, oh, you're very talented for insert, marginalized group here. You're pretty for a Black woman. You're such a good attorney for a Black person. Like these are like examples of things that seem like just offhand comments, but could really damage someone's confidence and their, hearing those kind of things would make someone feel very excluded from social spaces, or and not want to continue to show up in those social spaces if they're consistently hearing these kinds of biased and prejudiced communications about their abilities or their qualifications. So as much as I appreciate the perspective of the attorneys who have testified today about the importance of connections to Vermont's legal community, I think that it is going to be helpful for increasing the diversity of the candidate pool for the Judicial Nominating Board if that is, if we consider the barriers that people face to joining a legal community that is overwhelmingly white and may include a lot of, there are barriers to joining that kind of a homogenous community for attorneys of color. So, it's all about expanding the pool of candidates who can apply and making sure that we're not just pattern matching our additional nominations to the existing population that we have, because that is not going to increase the diversity of the judicial branch. Thank you. So that's the extent of my testimony on behalf of the office, and I'd be happy to take any questions the committee has, although I know we're running short on time here.
Any questions?
No.
Thank you so much, Jay. Appreciate the testimony.
Thank you very much. And I've sent the links to the H401 and to the second Racial Equity Task Force report to Committee Assistant Donsbach, and CC'd members of the committee if you'd like to read a further kind of in-depth explanation with research on why these recommendations were made.
Thank you.
Okay.